Welcome to the Law Firm Practice Management Advice Podcast.
The fundamentals of business.
Join Kirk Stange of Stange Law Firm as he discusses helpful strategies, tools, and insights to grow and manage a legal practice.
Good ideas are simple.
From improving client relationships to managing your team and scaling your practice, this podcast offers practical advice for navigating the challenges of law firm management.
Shall we proceed?
Now, here's your host, Kirk Stange.
Welcome to Law Firm Practice Management Advice. We have an interesting topic. The topic today is competent, diligent, and communicative representation. And this episode today is based on an article on my blog, lawfirmpracticemanagementadvice.com, dated June 8th, 2025. And the title of the article is Ensuring Competence, Diligence, and Communication. So as a follow-up to the episode today, go on over to my blog and read this article on this topic for more information. But let's go ahead and jump on in. Obviously, any law firm is going to need clientele, and the more clientele, typically the better. To attract new clientele, obviously a law firm has to have a successful marketing plan. It's also vital as well to make as many clients happy as possible, because former clients are a great referral source to any law firm. Okay, but after getting these clients, after obtaining these clients, one of the most important things any lawyer or law firm has to do is provide competent, diligent, and communicative representation to their clients. And the reality is these are ethical rules. I think any lawyers listening to this podcast will know, ethically, we are required as lawyers to be competent, diligent, and to communicate with our clients such that they're able to make informed decisions about the representation. But not only do the ethical rules really require this, but if you want to have happy clients, you've got to do this as well. Clients are happy when their lawyer is competent. They're happy when their lawyer is diligent, and they're happy when their lawyer communicates with them. Now, there are exceptions to these rules, but I think as a general rule, these ethical rules are really a roadmap to having clients that are very happy with the lawyer or the law firm's services. And if they're happy with the lawyer and law firm's services, they're going to refer other people to that law firm. They're going to leave positive reviews about the law firm. They're going to tell others in the community that, listen, this lawyer or law firm did an excellent job and you'd be in good hands if you use them. So is a law firm owner, as a lawyer, if you want to organically get referrals from former clients and to have goodwill in the community, be competent, be diligent, and communicate with your clients. It's very, very important. These are things that clients going through any kind of matter are going to want, and it's why these are ethical rules, I presume, okay? But in talking about this, let's look at the rules themselves briefly, okay? Again, keep in mind there's the ABA model rules of professional conduct, and certainly each state has adopted these, and there can be different nuances by the state. But we'll go through the ABA model rules today. And the first rule is competence, which is ABA model rule 1.1. And what the rule says is that a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Okay, so lawyers have to have the legal knowledge, and that might mean doing legal research, reading statutes, reading case law, honing their skills, and being thorough. So lawyers, be thorough with your court preparation. Be thorough with the documents that you draft. Thoroughness is part of being competent as a lawyer. And then the rule talks about being prepared in a reasonable, necessary manner. So when you're going to court, be prepared. When you're drafting motions and legal documents, be prepared. Know what you're doing. Okay, this is the hallmark of competence. All right. Then there's the rule on diligence, which is ABA model rule 1.3, and it states that a lawyer shall act with reasonable diligence and promptness in representing a client. And so, look, in essence, a lawyer needs to move with some level of speed. Right? To many clients, they want their lawyer to be fast. They want them to get things done. They want them to get the case to a conclusion. They want them to file motions, file the pleadings, do the necessary work in the case to get the case to conclusion, okay? So if lawyers are going slow, cases presumably take longer. If lawyers aren't filing motions and pleadings promptly, this can delay resolution to a case. So lawyers, you've got to move. You've got to have some efficiency. And obviously the diligence rule and the competence rule leave some interpretation out there. But as a whole, you've got to be prepared, you've got to be thorough, and you need to move with some level of speed, diligence, okay? And then you've got the rule on communication, which is the longest of the rules, and this is ABA Model Rule 1.4. And it states that a lawyer shall promptly inform the client of any decision or circumstance with respect to the client's informed consent as defined in Rule 1.0E as required by the rules, to reasonably consult with the client about the means by which the client's objectives are to be accomplished, to keep the client reasonably informed about the status of the matter, to promptly comply with reasonable requests for information, and to consult with the client about any relevant limitation on the lawyer's conduct when the lawyer knows that the client expects assistance not permitted by the rules of professional conduct or other law. And then B, a lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. So obviously this is a lot longer rule. There's a lot more to this, but some big takeaways from this rule, obviously, is you've got to keep the client informed about the status of the case, right? So you got to let them know how the case is progressing. Various state bars out there, in relying on this rule, talk about doing a monthly status letter to clients to keep them updated on the status of the case. I personally think this is an excellent thing and something that lawyers ought to do. Okay, and then you've got to properly comply with reasonable requests for information. So if the client's calling you, if they're emailing you, you've got to respond. Obviously, there's some interpretation here. Do you have to respond the same day? Is responding within 48 or 72 hours good enough? Or if you respond in a week or 2 weeks, is that good enough? I mean, this is all up to interpretation in a lot of respects, but I mean, typically the quicker you respond in terms of a client relations standpoint, the better, and probably ethically. The other big piece from this rule that when I read this rule, my eyes kind of key on is the language about a lawyer explaining the matter to the extent necessary to permit the client to make informed decisions about the representation. So, look, it's like a waiter or waitress who goes to the table and gives like the options in terms of the specials that are out there, right? You could get the filet mignon, you could get the chicken, you could get the pasta. Here's the pros and cons of each. A lawyer ought to do this in terms of advising their client. Okay, we've got option A. Here'd be the pros and the cons. Here's option B. Here's the pros and the cons. Here's option C. Here are the pros and the cons. Client, how are you feeling? Option A, option B, option C. Okay, oftentimes this can be tough for some lawyers because they're just thinking, we're going to do option A. Why do I need to explain option B or C? Option A is the way to go. But under the rules, the lawyer does have to explain the options and give the client enough information that they're able to make informed decisions about the representation, okay? So these are, to me, as a lawyer, very important rules. I think the roadmap for having happy clients. And so then you get into, okay, how do you make this happen as a lawyer or a law firm to make sure these rules are being employed, okay? Obviously, every law firm is going to be a little bit different. The area of law they practice in, the nature of their firm, okay? Maybe the geographic location where they're at. It's going to look a little bit different, but I think one of the great things a law firm can have is have a case checklist, if you will, in terms of how to progress a case. So within each file, if you have a case checklist that talks about, okay, petition, and did you file an answer? Did you file a counter petition or a counterclaim? And have you done necessary discovery? And have you looked at hiring expert witnesses? And have you done necessary depositions in the case? And have you done trial preparation like subpoenaing witnesses and outlining questions and right, so on and so forth? Obviously, this is going to vary, but the bigger law firm you have with the more lawyers working for you, having a case checklist within each file is a good thing because it can ensure lawyers aren't forgetting things and it can serve as a reminder. So from my vantage point, a case checklist that reminds lawyers about the things that need to happen in a case in a general sense is a very, very important thing. And if you want, you could have your lawyers actually check next to each item an initial and date when they've done the task. Or if the task is not applicable to the case, they could initial and date and put NA next to it, not applicable, if it's not applicable to that specific case, okay? But having some kind of case checklist, I think very, very important. because a lot of lawyers will forget about important things in a case. But if they have a roadmap, if they have a checklist, and this could be in the paper file or in a practice management software, if it's there, this can serve as a reminder, oh yeah, I haven't done interrogatories in this case, and oh yeah, I've been meaning to hire that expert, but I haven't done that yet, okay? So having some kind of checklist, I think, is a big key. All right. Another big key is having regular meetings within the law firm, okay? Particularly more senior lawyers meeting with legal staff and associates and junior associates and people with less experience to talk with them about either the cases they're working on or the tasks they're assigned to make sure that the lawyers and the legal staff are doing what they need to do, that they're complying with the rules of professional conduct, that they're not forgetting something or omitting something that's important, and just doing this on a regular basis to me is very important. Now, obviously, this is going to vary based on the firm. But once a month, once every 2 weeks, once a week. What you don't want in a law firm is to have a bunch of lawyers working for you and you never check in with them to see how they're doing, how they're working up their cases, how they're preparing their cases. You don't want that, because if you got a lot of lawyers in your firm, they might be forgetting key and material things that need to happen in a client's case. So having these regular check-ins, I think, can be very important. I've always referred to these as pulse checks, where you sit with the lawyer who's less experienced, you check their temperature, you check their pulse, you make sure they're feeling okay, that they're preparing their cases appropriately, and that everything's moving as it should, okay? So I think regular meetings are important. You don't want to just have attorneys working in your firm and you got no oversight going on. All right, I think that's important. I think another big thing is limiting lawyers' caseloads, okay? Some lawyers can be very charismatic. They're very good at retaining new cases, bringing in new cases. It's a wonderful thing, but every lawyer has their limit. There's a certain number of cases where it gets to be too much, and when they got that many cases, they can't call people back. They can't email people back, at least not quickly. They're not prepared in court as they should be. They get burnt out, stressed out. They're not prepared. They forget the facts of their cases and these kinds of things because they got too many. So to me, in any law firm, and there's going to be a different way to do this, but there's got to be a general limit on the number of cases you allow a lawyer to handle. And it could be a situation where it's just a hard number, like this is the number of cases I let you have and that's it. It could be that you have them rate cases on complexity. I've always done it. You rate it 1 to 5. 5 is super complex case, 1 is super easy case, 3's average case, and you rate it. So you look at a case rating. But managing this, particularly in the larger law firm, where there's a lot of attorneys, a lot of associates, very, very important, because you just don't want to have a situation where you have a good lawyer, but they're not doing a good job because they have too many cases. Okay? So these would be 3 simple steps, I think, in a lot of law firms to ensure the competent, diligent, and communicative representation. All right? I also want to talk about some of the other challenges that lawyers and law firms have in terms of ensuring that lawyers and legal staff meet these ethical duties to be diligent, competent, and communicative. Okay, one of the ones I've found is that lawyers will rely on the ethical rule that says, lawyer law firm shall charge a reasonable fee, and then it has these various factors about a reasonable fee. Obviously, this reasonable fee rule is important, and lawyers have to abide by it. It's certainly an ethical requirement, and it is definitely as important as the diligence, competence, and communication rule. So you have to charge a reasonable fee, okay? But one of the areas at times where lawyers can go off course is they just hinge on reasonable fee to think I should do as little as possible. And by doing as little as possible, I'm charging a reasonable fee. And this is particularly true if the lawyer's billing hourly. So they think I'm going to do less on this case because by doing less, the client's bill will be less. And if the client's bill is less, the client's going to be happy about that. And I certainly can't get in trouble for charging an unreasonable fee because my fees are low. Okay, the problem with this is a lawyer can do nothing on a client's case, but in that or very little on a client's case, but in that circumstance, are they being competent? Are they being diligent? And are they communicating if they're not doing much on a client's case? See, in these circumstances, lawyers will take the reasonable fee rule and elevate it above competence, diligence, and communication when all 4 of these rules are equally as important. And so the trick is a lawyer has to do all four of these things. They have to be diligent, competent, communicative, and they have to charge a reasonable fee. So there's this nirvana that has to be met in terms of all these rules. And at times for lawyers, it can feel like walking on a tightrope. There can be times where you're just super competent and super diligent and super communicative, and you could run up the client's bill to an area where it's unreasonable. But the opposite can also be true, where you're not competent, diligent, and communicative at all, and your fees are low. But man, now you've run afoul of those three rules to be competent, communicative, and diligent when you've got to do them all. Okay, there's another ethical rule that comes into play too, which is the duty to expedite litigation. And so if you're not doing much on a client's case, you might not be expediting litigation. So throw that in there as kind of a fifth rule that you have to kind of balance for purposes of this conversation. Obviously, there's a lot of other ethical rules as well, but as a lawyer, it can be a tricky deal where you've got to be competent, diligent, you've got to communicate, you've got to charge a reasonable fee, and you have to expedite litigation. At times, it can seem tough. How do you do all these things? That's what makes it very difficult as a lawyer. But the truth is all these rules are important. They're equally important, and really stressing this in a law firm is vital. And the other thing I would say, lawyers recording their time truthfully, honestly, and accurately is important, not just from a billable hour perspective, but it can also show that the lawyer is being competent, that they are being diligent, they are communicating, where there's billable entries to show that they're doing these things. It's hard for a client to later say, hey, the lawyer wasn't working hard on my case, because there's the billing entries to show it, right? And the billing entries to show that the case was being expedited. Again, you just don't want to go overkill where the fee becomes unreasonable. But on the flip end, if you're doing work that's needed, that's necessary, that's required to be competent, communicative, diligent, and to expedite litigation, then from my vantage point, that's what lawyers are supposed to be doing, all right? Definitely an interesting topic, okay? Vital that law firms stress this with their lawyers and their legal staff, the importance of being competent, diligent, and to communicate, all right? This is the episode today. Thanks for tuning in. As a follow-up to our episode, go on over to lawfirmpracticemanagementadvice.com and read the article dated June 8th, 2025, titled Ensuring Competence, Diligence, and Communication, and this will give you more information on this topic. All right, thanks for tuning in. Stay tuned to our next episode coming up. Thank you very much.
Thank you for listening to the Law Firm Practice Management Advice Podcast with Kirk Stange. Kirk Stange is the president and founding partner of Stange Law Firm, a multi-state divorce and family law practice. For more insight on similar law firm management topics, visit his practice management advice blog at lawfirmpracticemanagementadvice.com.